Good evening. How are you feeling this lovely Saturday evening? I want to answer two questions, okay? In this video, we are going to be talking about adjustment of status, the process by which an individual can adjust their status to a green card. Applying for a green card within the United States. That's what we mean by adjustment of status, okay? My name is Bijoux Ngwanda, as you know it. I'm an immigration lawyer based here in DC. However, I do have clients across the country and around the world because we are dealing with complex U.S. immigration law cases every day. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like. Don't forget to comment below. Also follow me on all platforms. Links are in the description box below. By the way, I'll be live on January 20th, 6 p.m. Eastern time. We're waiting because we want to have something more concrete to discuss. You know, we want to talk about the actual policies that are going to be implemented. We want to talk about the actual executive order because we're tired of speculation, okay? We know major changes are coming, but we really want to see it before we start talking about it because we already talked about it a lot. If you want to know more about those major changes that are coming, well, you go on my TikTok. Yes, we're venting over there. We're talking about those type of things over there. But here, we really want to focus on something more concrete, okay? That's why our live session is going to be, the first one of this year is going to be on January 20th. That's why you need to hit the notification bell so you don't want to miss out because I'll be answering questions live, okay? And bring all your questions. Yes, let's get right into it. Two questions only. One person asked, is it good to adjust status with USCIS or is it good to adjust status with the immigration court? What is the best possible way? The answer is very simple. You adjust status with USCIS if you are not in removal proceedings. That's just, if you're not in removal proceedings, there is no way you're going to be in court trying to adjust status in court, right? So if you're not in removal proceedings, you file your application concurrently, especially when the visa is available. Immediately available, like for immediate family member, a spouse of a U.S. citizen, for example, you file I-130, I-485, and all those other supplemental forms with USCIS directly because the person is not in removal and the person has to meet the eligibility requirement for adjustment of status, right? We are talking about this issue knowing that the person already met the requirement for adjustment, right? Then they file the adjustment of status with USCIS. But when do you adjust status in court? You adjust status in court when you already have your I-130 approved. Let's say you have a master hearing and you have a I-130 already approved. When you enter your pleadings, because on your master hearing, that's when the judge is gonna come with the notice to appear and, you know, basically notify you of the charges that appear in the notice to appear. And that's when you enter your pleadings and you might either deny those allegations or admit to those allegations and pretty much concede or do not concede. But anyway, that's when you enter your pleadings, and it comes a time where they're going to ask for what type of defense are you going to pretty much argue here in court. If you already have I-130 approved, that's when you say adjustment of status, and the judge is going to order you to file for your application for adjustment of status. That's just how it works. So, but let's say the I-130 is pending, and then what are you going to say? You're going to say, well, I-130 is still pending, but we're planning to adjust status. And then the judge is going to continue the case sometimes. But sometimes you already have your asylum already there. That was the case was referred there. Then you're gonna go with asylum, and once your I-130 is approved, then you're gonna go back to court, terminate removal, and try to adjust status with USCIS, or ask if the court will allow you to adjust status in court. At that point, it's just up to the judge, right? You don't decide. It's the judge that will decide, because you already into your pleadings. You never mentioned that before, so it's just gonna depend if the judge is gonna accept that, and then you're gonna just in court on your individual hearing. That's just how it works. Okay, that's just procedurally how it works, and you know there are always exceptions in every rule, but we're just talking in general how it plays out. And another question was, can I just status because I am under humanitarian parole? People who came to the border under humanitarian parole, or people who were paroled under humanitarian parole, they usually receive the C11 type of work permit. And another person was asking if they can adjust status. The answer is yes, you can adjust status if you qualify, of course, for adjustment of status, sometimes even under employment, provided that at the time you apply for the green card, you're still within lawful status, meaning you're still under that 2 years parole, or maybe the renewable parole, because some people get 2 years, then they renew it, they have 4 years. Those type of individual can get either sponsorship by an employer or sponsor themselves. They qualify under national interest waiver or EB1. So it's just going to depend case by case individual. But the thing is, the fact that that person has humanitarian parole, meaning they're here within lawful status, a lot of things can change for them. So you just have to take advantage of it, okay? If you need a consultation and you want to brainstorm to know what you can do about your case, please schedule it by using the consultation link in the description box below. Until next time, bye-bye.